A number of industrial relations offences have been filed at the industrial court since the start of the COVID-19 pandemic. This according to the president of the Industrial Court of Trinidad and Tobago, Deborah Thomas-Felix, who gave an address this morning during a special sitting of the Industrial Court to commemorate the beginning of its 2020-2021 law term. Her Honour Thomas Felix said some of the offences relate to business owners who have implemented measures such as reduction in hours of work, layoffs, and termination of employment. She added some of the measures are not part of people's contracts of employment, nor are they contained in collective agreements.
The pandemic ought not to be an excuse to flout the principles and practice of good industrial relations, to flout labor standards, and to flout the laws of this country. The jurisprudence of this court is very consistent on the issue of the unilateral imposition of new terms of employment and the unilateral variation of the existing terms of contracts of employment.
Mrs. Thomas-Felix said in times like these, employers should not consider a unilateral approach to the resolution of issues, especially as they relate to the current pandemic and how they affect the workplace.
It is unlawful for an employer to unilaterally alter the existing terms and conditions of employment of workers. Employers are reminded that they must respect and adhere to the rule of law when making these tough decisions, which affect the livelihood of workers and the survival of their businesses.